Well, welcome everybody to another episode of HSF Kramer's Defining Matters series. Nicole Pedler, good to be here with you again.
Good to be here.
Now, Nicole, when you think about defining matters in the last few months, there is no bigger defining matter than the Dexus litigation, which has firmly brought into focus how divesting parties manage confidentiality obligations in a sale process.
Indeed, this is an important one. Contextually, in 2022, it was a big moment when it was announced that Dexus was acquiring AMP Capital, the asset management business of AMP. It was a big pivot for Dexus, and it diverted the then demerger of AMP Capital. And as part of that, they picked up AMP Capital's management rights of APAC. APAC owns Melbourne's important Tullamarine Airport, also Launceston Airport. So, jewels in the crown types of assets.
Absolutely. And Justice Hammerschlag of the New South Wales Supreme Court has handed down a very well-written judgment, and one of the best lines of the judgment, the parties are now locked in mortal combat. I love that.
It does have some flair. He didn't have to look too far in this one. There was a lot happening. And in terms of what did happen, roll it forward to 2024, and they were looking to divest part of the stake that they managed. And in doing that, you look at that 1997 shareholders deed, and it had a couple of pathways, the main one being what we'd expect in a JV context. There's a preemptive rights process whereby if a divestment's going to be made by one shareholder, then it must first offer it on quite prescriptive terms to the other shareholders. That's one path. There's always an exception to that for what's called affiliate transfers within a controlled group, or in the case of an asset manager, transfers to some degree, depending on the drafting, around the group that is sort of controlled or managed by them. And so Dexus proposed to use the transfer route through that path. Using that path, though, there are obviously some challenges.
Yeah, and the key one, Nicole, confidentiality restrictions in a shareholders agreement. That prevented Dexus from disclosing information to third parties. The exception to that was disclosure to a potential purchaser, but that was subject to the prospective purchaser agreeing a confidentiality agreement that was to the reasonable satisfaction of the other shareholders and enforceable by them. So a very important part of this judgment is effectively the caveat to disclosing to a prospective purchaser. Effectively, Dexus thought it had a pre-agreed form of confidentiality deed. Ultimately, on the evidence, they couldn't prove that that form had been agreed by other shareholders. And in addition, some of these potential purchasers that were brought into the data room had negotiated amendments through side letters. So there were variations to the form, even that Dexus thought had been agreed by the other parties. The judge ultimately found that that form could not be proved to have been pre-agreed. And effectively, that resulted in a breach by Dexus of the confidentiality restrictions.
Indeed, and it was partially the way that this had occurred and the way the sale process had been run meant that it wasn't, for example, one or two final parties that had received it. It was some 40 different types of organisations of recipients, 137 separate entrants to the data room had been recipients of what was the most critical commercial document or model that formed part of the business.
Yeah, and that's exactly right. The financial model for the business had been disclosed to these potential purchasers. The context, again, to sort of colour the severity of the potential consequences of the breach. The APAC was negotiating terminal access arrangements with certain airlines as this sale process was underway. Some of the potential purchasers had linked to sovereign wealth funds that effectively were affiliated with national airlines. So we're not suggesting that there was anything untoward, but you could see that in the wrong hands, that information really could adversely impact APAC.
And the way that this came out with APAC itself is its own really interesting piece of the judgment. Dexus had informed APAC's board that there was a transfer process underway. It's a very challenging thing from Dexus's perspective, I think, in the sense of how do you manage the right pathway to obtain the right kind of value for your investors in an exit in the context of what is a preemptive rights regime negotiated in the 90s that wouldn't match on to what we would call a modern sale process today. So I do think that you've got to give all sale parties who might find themselves in this position a moment to sort of look at how they design these kinds of processes with these old JV agreements in a modern context. But in effect, they described it as a transfer, hadn't described it as a competitive sale process, and certainly not to the scale that they had ended up conducting. And it ended up at the point where they had a couple of preferred bidders who considered that they needed to make this kind of investment face into APAC and receive some management information. And that's where it really started to come apart.
Yeah, and that's effectively how APAC sort of uncovered the extent of the information disclosure. Dexus effectively needed to arrange with the potential purchasers and APAC management sessions to go through their sort of answer the questions for prospective purchasers. As part of that engagement, it became apparent to APAC management that these potential purchasers were very, very well informed by the business, and management escalated it to the board and said, look, we think there's been broad disclosure here. So what followed was the rest of the board effectively questioning the Dexus directors as to what had taken place, and eventually all the facts were brought to their attention. The next step in the chain, the board was very troubled by the disclosures that had taken place, and effectively they issued a default notice under the shareholders' agreement for material and irremediable breach of the shareholders' agreement. That commenced a process that would have allowed the other shareholders to effectively buy the entire Dexus block, not just what they wanted to sell, the entire block managed by Dexus. Pretty severe consequence given the importance of the management rights over the shareholdings. Dexus effectively injuncted that, and that's what resulted in this judgment.
And fast forward through what was the court process itself received its own media attention for various reasons. And we have findings from the judge that in effect, when you're looking at a breach of something like this, where it's information, once it's in the hands of those who shouldn't receive it, that's a type of irremediable breach. This is kind of an interesting point on its own, in that maybe in tech and other scenarios, we do see situations where information is put into the hands of those you shouldn't expect it to be in, and there are pathways for curing. There's deletion, there's confirmation that that's happened, and those kinds of steps that can be taken. Here, what added to it was the nature of the parties who received it and the way in which the pathway had happened to it reaching their hands. A lot was made of a breakdown of trust at the boardroom between Dexus and the other directors.
Absolutely, Nicole. And so when looking at material and irremediable breach, the judge effectively said that it doesn't have to be a fundamental breach to be a material breach. It doesn't have to be a breach of a material obligation. What determines the gravity of the breach is the seriousness of the effect on the relationship between the parties. And to your point, the judge here found that the disclosure and the manner of the disclosure, and also the manner in which it came to light, had effectively resulted in a breakdown of trust and confidence that the other shareholders were entitled to enjoy under or benefit from under the shareholders' agreement. That had broken down, and effectively that was irremediable, notwithstanding that Dexus issued destroy all information notices. Dexus offered to have the potential purchasers sign up new confidentiality agreements, but the judge ultimately found that that would not be a perfect remedy as the trust and confidence had broken down.
And I think that's an important point to pause on if we move then into the lessons for transactors, because if you take a step back, Dexus did require confidentiality agreements to be entered into. A number of the exceptions that were negotiated in, and much was made of the fact that, of course, yes, the joint venture agreement required the other investors, existing investors in APAC, to have been parties to it. But at the same time, a lot of the exceptions that were negotiated in on their face are things that there's no contracting lawyer who works with NDAs who wouldn't, in this day and age, expect that something that allows backup records that are undeletable not to have been captured in an exception. I think it's important that we, in moving into the next step and looking at how we deal with this, ensure that we kind of accept the reality parts of it, that they were having to work with it. But if we do move then into what are some of our lessons, I think if we start at the beginning, we've been negotiating a number of these sorts of agreements live while this case has been going on, and it sort of turns your attention back to some of these provisions. And the nice thing about joint ventures is that you code at the beginning for the end. And so an important thing to do is to really stare into the next 3, 5, whatever the timeline horizon might be for exit, and to consider what are all the pathways that are realistic? What are all the different permutations that genuinely you think might be there for this particular asset? And you can even throw additional ones into the mix in terms of, we've seen in the last few years, we've had careful consideration in these kinds of agreements in relation to assets that would possibly quite fittingly end up on public boards. And how do you deal with prospectus disclosure and that kind of thing? So starting at that drafting stage, I think, is important.
For me, Nicole, one of the really key lessons is the courts will apply these contracts very strictly. And sometimes you hear people, when thinking about confidentiality restrictions, they say, well, the potential purchase is subject to a market standard confidentiality deed. So that's the protection. Well, why do we need to go further? And, very much on the back of Dexus, the answer is, no, you've got to comply with the strict terms. And in this case, the other shareholders had the right to ensure the confidentiality deed was there to their reasonable satisfaction. It's not enough just to have a market standard NDA. The other interesting thing for me was the default notice, Nicole. In this context, the shareholders' agreement said that the board would issue the default notice rather than the shareholders. There was a lot of evidence, and the judge goes into quite a bit of detail during examination and cross-examination of the board members as to what was their motive for issuing the default notice. While the directors, and what became apparent is, while the directors were aware that the consequence of issuing the notice would be that the other shareholders would potentially acquire the stake, it was found that was not the primary motive of why they issued the notice. Instead, it was responding to the breakdown in trust and confidence and ensuring that the confidentiality information going forward would be protected. So I think Dexus pushed very hard to say, look, all of this is designed to disenfranchise the Dexus block of their shares, but the judge ultimately found that the board had a legitimate reason and had acted in good faith in effectively issuing the notice. If we think about the lessons, one thing for me is it right that that notice comes from the board, or should you draft for that notice to come from the shareholders? Now, the board will be subject to directors' duties, and there wasn't a lot in terms of argument on whether the directors had breached their duty. I think the evidence suggests they had not, but it adds another layer of consideration, whereas at the shareholder level, those directors' duties do not apply. There is still an argument as to whether the shareholders have to act in good faith and for a legitimate purpose, but I think it's a different type of consideration for shareholders relative to the board.
Indeed, and on the flip side of that, it's almost a helpful underscore that Justice Hammerschlag has given in that, yes, read the terms strictly, assume they'll be applied strictly, and that things like ulterior motives and that kind of thing are not going to be some sort of escape hatch.
Absolutely.
In the case of non-compliance.
Absolutely. The other one on the drafting point I've been thinking more and more about is, should there be a pro forma form of confidentiality deed attached to a shareholders agreement that would allow the party to rely on that potential purchaser exclusion? Had Dexus had that, then they would have had a definite document that they knew had been agreed by the other shareholders. And when you're interfacing with your potential purchaser, having the discipline not to stray from that standard form, I think this case really emphasises the importance of that.
Indeed. One of the other pieces, I think, is DD and sale processes generally. It's challenging in any sale process, I think, especially for the kind of participants that are involved, level and sophistication. It's fair to assume that for any prized asset, there'll be an interest to seek interest broadly. Usually, if you call it a teaser stage, a stage that starts before even an indicative offer letter is requested, before an information memorandum is provided. Usually there's a teaser stage. You might follow that with an information pack and request indicative offer letters, which then maybe you have your select few who manage to make it into a data room. In your data room, you then might stage the information that's provided, might decide what's in black box, thinking of all of these sorts of things as we've said, underscoring this compliance with all confidentiality obligations along the way now as expected. But how do you think that process changes in light of this decision?
I think you're absolutely right, Nicole. I think more staged information, careful controls around the number of participants that may get access to that information, just a lot more practical guardrails around how confidentiality is protected. Look, I for one, and I know you're the same, Nicole, we advise a lot of vendors early on in a transaction to make sure that managing confidentiality is really a transaction priority. And sometimes not all the stakeholders appreciate the gravity of how important that is. I think the Dexus case brings it firmly into focus. And I, for one, feel vindicated for some of these divestment processes having raised confidentiality concerns as material and potentially quite destructive if you get them wrong.
We've obviously been talking about this one in a very live context. We don't know yet whether the decision will be appealed and if there'll be any further findings. But certainly it's given us pause to reflect on process and some really important features of joint venture agreement formation and also sale processes going forward. And I think some important learnings have come out of it for all market participants.
Absolutely, Nicole. You're previewing a potential second episode once if and when we get an appeal. But I know a lot of the M&A community is watching this very, very closely, and rightly so, because there are much broader ramifications for a lot of sale processes, not just the JV context, but also 100% sales. I think the principles are equally applicable in that context as well. Well, it's been great to hear your thoughts on the Dexus case, and for participants in the market, if you have confidentiality concerns, of course, we're always happy, Nicole and I are happy to discuss, as well as the broader M&A team here at HSF Kramer. We trust that's been enjoyable, and we'll catch you on the next episode.